I will first make some general observations about money laundering in Singapore before raising 3 queries about the bill. So this bill is part of Singapore's efforts to enhance its anti-money laundering measures. The Workers' Party supports the bill. Nonetheless, if implemented, this bill is just part of an entire ecosystem that needs to be scrutinized for gaps and vulnerabilities. Member He Ting Ru will speak later about some areas of concern regarding Singapore's ecosystem. Sir, Singapore is one of the 40 members of the Financial Action Task Force, or FATF, which conducts mutual evaluations on the ecosystems of countries. The most recent mutual evaluation by FATF on Singapore was done 8 years ago in 2016, with the next one due next year. In the 2016 evaluation, Singapore was assessed to have a mostly robust and competent regulatory system when it came to financial institutions. However, the same could not be said for sectors outside the finance industry, collectively known as Designated Non-Finance Businesses and Professions, or DNFBP. The DNFBP sectors were noted to lack many of the obligations and supervisions that financial institutions were subject to. The 2016 evaluation identified that we did not have a strong awareness of illegal fund flows from foreign predicate offences. It also pointed out that the private sector had weak knowledge of money laundering risks from transnational transactions. Fast forward to today. Singapore just published its own Money Laundering National Risk Assessment, or NRA report. This report concurred that there were significant risks in the DNFBP sector which needed to be addressed. Last month, this House took a step in the right direction by enhancing the requirements on corporate service providers. Other private sector industries, such as real estate and luxury retail, have rightly been identified as needing to be stepped up too. To illustrate, we just need to look at the recent $3 billion money laundering case. The money launderers had managed to channel their ill-gotten gains into Singapore with the purpose of washing them through items of tremendously high value. For example, just one of the men involved had purchased 10 condominium units at Canning Hill Piers worth $85 million, a transaction in which red flags should have been raised. It has since been reported that some real estate agents were being investigated for giving kickbacks to their clients from the huge commissions earned. It is clear then that an effective AML approach needs not just a robust framework. How it is executed is key. To this end, Member Dennis Tan will seek clarifications later on the adequacy of AML due diligence measures in the recent cases. I now move to the bill before us. On this, I have 3 queries. 1 on restitution to crime victims, 2 on the change in the law to Jeanette Ang's case, and 3 on suspicious transaction reports. First, on restitution to crime victims. In the government's recent paper, National Asset Recovery Strategy 2024, it was stated that the strategy had 4 operational pillars. I was pleased to note that under Pillar 3, the strategy aims to, and I quote, deliver maximum recovery of assets for forfeiture and restitution to victims, unquote. The paper affirmed that Singapore adopted a victim-centric approach towards asset recovery. I agree that where offenders have profited at the expense of victims, then the assets purchased using such fruits of crime should rightfully be delivered to these victims. I therefore welcome the provisions such as clauses 7 and 14 of the bill, which will help ensure that the value of seized assets is preserved. One challenge regarding delivering restitution to victims is that money laundering is typically transnational in nature. The victims of crime are often located in other countries. In the Asset Recovery Strategy report, it was stated that in the 5.5-year period between January 2019 and June 2024, authorities here seized about $6 billion in assets. Out of this, the majority of $4.6 billion is still tied up in ongoing investigations and court cases. This leaves about $1.4 billion freed up to make restitution, out of which $416 million, or less than 1/3, has been returned to victims. During the parliamentary sitting in July, I had asked whether it would be too late for victims to make claims after a Singapore court had already forfeited the assets. MHA had indicated that it would still be open to foreign parties to make requests for mutual legal assistance, or MLA, even after the court had made forfeiture orders. For us to assess whether the MLA route is meaningful for victims, could the Ministry confirm how many countries have filed MLA requests with Singapore in the last 2 years, and which 3 countries have filed the most MLA requests? Next, I move on to the change in the law arising from Jeanette Ang's case. I have a query on the change in Clause 11. Clause 11 will amend the law set out in the 2011 High Court case of Ang, Jeanette and Public Prosecutor to make it easier for the prosecution to prove certain money laundering offences. Let me summarize why. In Jeanette Ang's case, the High Court had ruled that to prove that an accused had committed money laundering, the prosecution needed to show that the monies in the accused's accounts came from criminal conduct. Clause 11 would remove this requirement. Instead, it would simply be sufficient for the prosecution to show that the accused had a guilty frame of mind, that is, that he knew or had reason to believe that the monies came from criminal conduct. In explaining the rationale for the change, the Ministry pointed to evidentiary difficulties. It was said that the proceeds of crime could have been channeled through other bank accounts in other jurisdictions before coming to the accused. It was stated to be difficult to obtain documents from foreign banks to prove the trail of monies. And I think earlier, Minister also touched on this point. So this amendment in Clause 11 would fall squarely within a concern raised by the judge in the Jeanette Ang case. The court in that case had stressed the importance of requiring the prosecution to prove the trail of monies. The judge noted that if the prosecution did not need to prove that the monies came from criminal conduct, then a person could be prosecuted for money laundering in situations where he mistakenly thought that the monies were the proceeds of crime, when the monies were in fact clean monies. The court opined that prosecuting such a mistaken person would not further the purposes of the anti-money laundering conventions and laws. With the change in Clause 11, how will this risk be addressed? So finally, on suspicious transaction reports. STRs are a key step through which the authorities are alerted to potential money laundering transactions. Clause 5 of the bill will increase the jurisdiction of the STRO, that is the Commercial Affairs Department. The STRO will soon be receiving STRs arising from additional legislation such as the Free Trade Zones Act, Goods and Services Tax Act, Income Tax Act, and the Regulation of Imports and Exports Act. In order to facilitate the work of the STRO, what can we learn from our experience so far about the filing of the STRs? In answer to a parliamentary question I filed in January last year, the Minister for Home Affairs revealed that the CAD received an average of 37,000 STRs each year from 2019 to 2021, or about 102 reports daily. I believe the numbers are much higher today, a point that Ms. Fumiha alluded to earlier. So what is concerning is that of the STRs filed in those 2 years, 2019 to 2021, the Minister reported that only 20% of them resulted in or supported investigations eventually. Does that mean that the other 80% were found to be of low quality and not actionable? Similarly, when it came to digital payment tokens or DPTs, a similar trend is being observed. According to our Money Laundering National Risk Assessment report this year, a majority of the STRs relating to DPTs did not point to any specific offence. So all this suggests a possible wastage of investigative resources to look into unactionable STRs. It may also suggest that the STRs are being filed defensively to avoid possible trouble down the road. Being unclear about the threshold that warrants the filing of an STR harks back to the earlier concerns expressed by FATF about the level of private sector knowledge in Singapore regarding AML risks. What is being done to promote a deeper understanding of what STRs should contain? So let me conclude. The Workers' Party is in support of the bill. I look forward to the Ministry's clarifications regarding the 3 concerns I've raised about restitution to crime victims, the change to the law in the Jeanette Ang case, and the quality of suspicious transaction reports.